So who's the insurance adjuster deciding whether or not to pay your injury claim? And does your attorney know who that person is and how to take advantage of their position? Hi, my name is Hunter Hostenbach. I'm with Hostenbach Law Group. Today we're talking about, well, who is the insurance adjuster that's handling your claim? Who's that person that's going to decide whether or not they're going to pay your claim and how much they're going to pay your claim? And it's so often that I get calls from attorneys that have just got what I would say is completely sideways with the adjuster. They have angered the adjuster beyond belief, and now they don't know what to do. The adjuster isn't going to pay the claim. And, a lot of times it's just a lack of empathy for that other side or a lack of appreciation for who the adjuster is as a human being that gets them in that situation. It's entirely the attorney's fault, and there's no reason for that. And it's harder to fix those situations than it is to just have some tactical empathy when you're dealing with the other side, in this case adjusters. So who are your adjusters? Well, they can be broken down into two basic categories. One would be a pre-litigation adjuster, and one is a post-litigation adjuster. What does that mean? Pre-litigation adjusters are any insurance adjusters who are looking at your claim, they're getting your medical records, getting any information about your lost earnings in relation to your injury, accident, and then they're deciding, okay, well, how much is this worth? And then they're going to negotiate that with the attorney. But they're the adjuster who is assigned before any lawsuit has been filed. That's why they're the pre-litigation adjuster. After a lawsuit has been filed, it's not always the case, but in most cases, after a lawsuit is filed and the defendant is served, the adjuster will be changed to a litigation adjuster. And there's really no difference between the pre-litigation adjuster and the litigation adjuster in terms of what their function is, and except that the litigation adjuster is going to have to get the case assigned to some attorney, be that in-house or outside counsel, and then they're going to have to manage the claim, not only trying to pay it or get it settled, but also they're going to be kind of the business manager, if you will, of the lawsuit for the defense, okay? So let's go back and talk about pre-litigation adjusters. How are they different from litigation adjusters? In job function, it's pretty straightforward. They don't have to deal with the lawsuits. Other than that, they're pretty much the same. But who they are as a person is wildly different than who the litigation adjusters are. And let me explain. So a pre-litigation adjuster a lot of times can be the person who's first day on the job to someone who's been doing it for quite a while, but they've never really excelled enough in their career, or maybe there's other reasons they just don't want to do it. But they've never really excelled enough in their career that they've been promoted to a litigation adjuster. They haven't been entrusted with those extra duties of a litigation adjuster. And that makes sense that the litigation adjusters would be the more senior people, because they're not just dealing with, getting the records from the plaintiff's attorney, me, and, then trying to negotiate a resolution of that claim. They're also having to deal with the deadlines of litigation. They're having to deal with approving the hiring of experts and approving litigation plans and strategies. They have to set budgets for the litigation. So there's a lot of duties that a litigation adjuster has to be in charge of that a pre-litigation adjuster they don't have to worry about any of that stuff. So you can expect the pre-litigation people to be less senior. And by less senior, that usually means they have less authority, they have less experience, they may not be as good at their job. It can mean any number of things, right? I've talked to pre-litigation adjusters who I'm quite certain they've never been trained a day in their life. They have no idea what they're doing. They call up and just do and say the wildest things. They get mad sometimes. I've had them get mad if, I'll send them an email really quickly. This happened just the other day. I sent one an email. I said, hey, you made an offer to my minor client before I got involved, and I just need to know what medical bills that you considered when you made your offer. And she called me on the phone just raving mad at me that I had asked that question. I mean, there was no reason to be mad about that other than she just obviously doesn't have any idea what she's doing. And she's not the first to do something like that. And I'm not saying all pre-litigation adjusters are bad, but if you're going to run into somebody who really doesn't know what they're doing, that's the pre-litigation adjuster. That's the one you're going to run into. It's very rare you're going to run into a litigation adjuster who doesn't know what they're doing. Those people are senior, they have experience, they're generally pretty good at what they do. So a lot of respect for them. Pre-litigation adjusters, they're all over the map. So what are some other basic things about pre-litigation adjusters other than, they wildly fluctuate in their terms of experience and expertise and ability to control their emotions, etc. A pre-litigation adjuster, no matter how good they are, their hands are tied behind their back. They usually, you've probably heard other lawyers talk about, this Colossus system that used to exist. I don't know if they still use it, I don't care. And it basically, there's always some version of it that's being used by every insurance company, especially at the pre-litigation stage. But they pump numbers into a computer or an algorithm, and then it pumps back a figure to try to settle the case around this figure. And it probably gives them a high and a low. Here's the low end, here's the high end. And that's within the range in which you can negotiate the case. That range is usually pretty small. The less experienced the adjuster is, the worse the insurance company is. Sometimes those adjusters, they have no ability to negotiate anything with you at all. They have to get authority from their manager on every single thing they want to do. And so their jobs, I feel for them. Their jobs suck. But their hands are tied. I mean, no matter what the specifics of that company is, their hands are tied in the sense that they're given very little leeway to really negotiate your claim. If they're given any leeway at all, it's a small range, but usually it's the case that they're constantly having to go to their bosses and ask for more and more and more authority. And then they're going to be capped a lot of times at a certain amount. And it may be $50,000. Like, there's no way we're going to pay this claim above $50,000. So you as an attorney, when you're working with a pre-litigation adjuster and you think a claim is worth $75,000, and once they start hitting that, once they start offering you up near 50, let's say they're at 45, then all of a sudden they start moving painfully slow as you negotiate. They go from 45,000 to 46,250, and then they go to 47,000, and then maybe they add a couple more $100 on there, and they're just trying to get underneath that top authority number of 50,000. But when they slow down like that there's no chance they're getting anywhere near your 75 mark that you want. And they may browbeat you into taking the 50 or something, just below that. But the reason they're doing that is because they literally don't have the authority to go over a certain number. You don't necessarily know what that number is, but they don't have the authority to go over that number. So again, their hands are tied. They cannot give you the resolution that you really want. That is by design. The insurance companies do that by design. That's how they keep the payment of claims at a much lower number than they probably should be. Used to, they even made it where, and they still do this in some cases, I think State Farm was the biggest perpetrator of this, but back in the day, but these things change over time. They used to even give you, for a time, they would give you a team. So you never would call one adjuster and negotiate with that one adjuster. It was a team. And you can't build a rapport as an attorney, someone who's trying to negotiate with somebody with a team. It's impossible. So the insurance companies did that on purpose. They were trying to keep you from building a rapport with those team members by always having you talk to somebody different every single time that you got on the phone. So yeah, that's pre-litigation adjusters in a nutshell. Their hands are tied behind their back. They may even be part of a team. Even if you could build a rapport with them, it kind of doesn't matter because they have so little authority to do anything anyway. That brings us to, who is the litigation adjuster? Litigation adjuster is again, there's somebody who has more experience. There's somebody who's seen thousands upon thousands upon thousands of claims. They've dealt with thousands of attorney personalities. There's really nothing that raises their blood pressure too much. They're pretty even-tempered, very even keel. And for the most part, they're pretty decent, people. They're smart. They know what they're doing, and they understand your position as an attorney and how pre-litigation adjusters make your life miserable as an attorney and make things hard for you as an attorney. And so you have to file a lawsuit just to get it in the hands of a reasonable person. They understand all that. So they're a lot easier to deal with. It's vital for the attorney when they're dealing with a litigation adjuster to treat them with respect and treat them as a colleague. Don't condescend to them. Don't talk down to them. I mean, your attorney shouldn't be doing that anyway to anybody, really, especially litigation adjusters. These people have a lot more authority and a lot more leeway to negotiate your claim, to pay you more money, and it just pays dividends over and over and over again to be respectful and to be kind to these people and to work with them, to be a partner with them or a colleague with them rather than trying to have the upper hand. Those are litigation adjusters. And litigation adjusters, let's say a pre-litigation adjuster has authority of only $50,000. A post-litigation adjuster, a litigation adjuster is going to have authority maybe of $150,000 right off the bat, or at least they're going to have $100,000 off the bat. And then just to get it right up to 150, all they have to do is ask a quick question to their immediate manager who's going to rubber stamp anything that they want to do. So you can almost always bet that at most big insurance companies, a litigation adjuster is going to have $150,000 authority pretty much immediately without much hassle. And so they have a lot more authority. They have a lot more room to negotiate. They have a lot more leeway to be considerate of you. They're not tied by a system that they're pumping numbers into and then spitting numbers back out at them saying you have to settle within this range. They're not obligated to that system. And the thing about a litigation adjuster is when you understand them, right, you understand that they have a lot of files on their desk. They have a lot of moving parts that they have to manage. They're managing litigation teams, they're managing deadlines, they're managing experts, they're managing budgets, they're managing this whole world of stuff it's a lot. Does your attorney understand these pre-litigation, post-litigation adjuster personalities? What drives them? What motivates them? Does your attorney understand that? And how can they take advantage of it? Well, the way that they can take advantage of it is they can push almost every claim into litigation, right? I mean, they literally could get claims away from the pre-litigation adjusters immediately by filing lawsuits once the claim is ready for demand and getting more money from a litigation adjuster because it's just going to work out that way. Let's say that you're a really big law firm and you have 5,000 personal injury claims and you're paying, just say here in California, you're paying roughly $450 every time that you file a lawsuit. Well, really about after you get it served, $500 every time that you file a lawsuit. Now you do $500 times 5,000 claimants. That gets expensive really, really quick. And then there's other costs that are immediately involved. So there may be business reasons why you don't want to push every single claim into litigation, but your attorney for the most part should be pushing a lot of their claims that have any value at all into litigation if they can. Especially if the pre-litigation adjuster is doing what we call locking up on them very quickly, which means, giving them obscenely low offers and not moving very much off of that. You just push that right into litigation. And so when you talk to your attorney on the phone, you should be asking questions about those kind of things. How are you going to handle this? How are you going to settle this case? Do you intend to file a lawsuit on it? If you do file a lawsuit on it, what do you expect to get? What do you expect to achieve by filing that lawsuit? Yeah, if somebody were to call my office, for example, and their claim was worth, if I thought it was worth $50,000 plus, or even if I thought maybe it was worth $30,000, I'd just tell them, look, I'm going to be dealing with the litigation. I'm going to be I'll send one pre-litigation demand, and I'll see what kind of offer they give. I'm also going to be talking to that pre-litigation adjuster a lot before I send that demand because I'm trying to build a rapport with them. And then, once I get a demand from them, I'm going to get a very quick read on what it is they want to do. I have a claim right now that's a very big claim, several million, well, anywhere from 20 to $50 million that my client probably is entitled to. And the insurance, as far as I know, the insurance available in the claim is somewhere around maybe $5-7 million because I haven't filed suit yet. But I have been in constant contact with the adjusters on the other side, and they've also hired attorneys on the other side who I've also been in constant contact with. And I can just tell by their lack of urgency in communicating with me when I'm starting to slowly ramp up the pressure of wanting to make a demand on them. I can just tell by their lack of urgency that they lack the motivation, they lack the proper motivation right now, in my opinion, to get this deal done. So what does that mean? I'm immediately pushing that file into litigation. So you have to build a rapport as an attorney when you're dealing with these adjusters to get a sense of where they're headed, to get a sense of who they are as a person, and to know where you are as a negotiator with them. And once you build that rapport and you get that first demand out, say they give you an offer, I'm going to be able to decide very quickly whether I need to push this file immediately into litigation or not. And then once I push it into litigation, you have to have a strategy. You don't want to be going to trial on every single case. This may be a case that needs to settle for you, the client's benefit. You get your money quicker. A jury is a lot more iffy what's going to happen with the jury. You can control your situation with an adjuster. So you have to have a strategy once you file a lawsuit on these. And again, I'm not necessarily going to give a blueprint for other attorneys to do that, but there is a strategy after you file the suit to get the thing settled. Your attorneys, if they're good, they should know all that stuff. So in any event, that's who your adjuster is. Remember, they're human beings. They're the ones who are making the offers. They're the ones who are going to pay your claim. But they're not big, bad, evil people. They're like you and me. They could be anybody from any walk of life. They can have all kinds of varying education levels. They can have all kinds of emotional stability or instability issues. They're normal people. And so you just have to understand who they are, treat them like human beings. And once you deal with them like that and you understand that, then you'll get a lot better results from your cases. And hopefully your attorneys understand that too. Anyway, I hope this has been helpful. Tune in for more of these videos. We have lots of them, and we hope that you're benefiting from them. Good luck to you, and thanks.